British Telecommunications PLC and the Commissioner for His Majesty's Revenue and Customs.
Yes. Good morning, Mr. Cordara.
My Lord, good morning. I appear, as you can see, for British Telecoms. I appear with Ms. Frawley and Mr. Rattan. My learned friend, Ms. Mitrofanous, appears for the Commissioners, and she will be joined as soon as he's released from another court in the building by her junior, Mr. Wilmot Smith. And as the court will know, this is an appeal and cross-appeal from a decision of Mr. Justice Miles, granting reverse summary judgment and striking out
Yes.
a large part of my client's case.
As you will expect, we've read the skeletons and the judgment, and at least some of the authorities, so we have a fair idea of what the issues are.
I'm grateful. You have very full skeletons. So.
We do have very full skeletons. So far as the bundles are concerned, I understand that your second supplementary bundle is now an agreed bundle.
Largely.
But Ms. Mitrofanous, for my part, I think quite rightly says that it's a bit of a sleight of hand to seek to incorporate by reference the entirety of your submissions below, and I don't think that you can really do that. I think if you want to make submissions, you make submissions that are hopefully foreshadowed in your skeleton.
Indeed.
And we will take account of what you say to us and what you have said in your two skeletons, but not what you say below, unless you make a particular point.
I won't try.
Yes. Thank you.
I'm sorry you've been troubled. My plan of attack, always subject to guidance, is to indicate in relatively short order, mindful of the fact that the court has read, the key elements of European law that are in play. So that will take probably about 10 minutes or so.
Yes.
Maybe 15. Then after that, I would propose to take a risk, which is to lay out before the court at high level the various themes upon which my case is based. The risk is that one gets drawn in to a detailed discussion prematurely in the presentation, but if so, so be it. But I'm conscious that it will, I hope rather, that it will help the court to have a clear idea, mindful of the skeleton anyway, of where we are proposing that the court goes. That's the second area. Third area is to plunge straight into the case law FII 2012, as we've been referring to it, the Supreme Court case on ouster and much more, but particularly on the approach to these residual common law causes of action or alleged causes of action in that most statutory of landscapes, taxation, because that ultimately is where we are in my submission in this case. And that will take me to the latter end of Mr. Justice Miles' decision, that is to say, where he turns to reject the submissions that have been made to him in that area. And the fourth and final phase will be to go to the specific 7, 8 or 9 very specific points that his lordship took against my clients of the classic ouster, the classic audit that judges make. And I leave those to the last. They're all important. And we hopefully have an answer to them. But it seemed to us that it was better to deal with the broad legal setting first. And so those 4 phases, I'm slated to, and I will, stop at 2:30.
That's simply on your appeal.
That's right.
Yes.
And then,
what is the timetable? So your appeal takes you to 2:30, then what?
my learned junior has got the timetable in his mind.
Yes.
So, he will tell you.
My Lord, apologies, we've just emailed this through, but if I might just quickly read it out. So BT submissions on issue 1, finishing at 2:30 today.
Yes.
HMRC will then begin its submissions on issue 1, which will carry on until 4:15 today.
Yes.
Tomorrow morning, HMRC will continue its submissions on issue 1, which are due to finish at 11:45.
Yes.
BT will then reply on issue 1, which will be half an hour until 12:15.
Yep.
HMRC will then begin its submissions on issues 2 and 3, which will go through until 1 p.m. And indeed will then continue after lunch until 4 p.m.
Yep.
BT will then begin its submissions on issues 2 and 3 between 4 and 4:15, and that will be the end of day 2. And then finally, on day 3, BT will finish its submissions on issues 2 and 3 by 12:45, and HMRC will then reply between 12:45 and 1 p.m.
Well, we're very grateful to the parties for having devoted so much attention to the timetable. We will try not to derail you by asking too many questions.
My Lord, then, so I come to the first of my 4 phases.
Yes.
Which is to state the obvious. This is a case about direct effect, and it is therefore a case which is infused from beginning to end with EU law considerations. By beginning to end, I mean throughout, for example, the ouster analysis, which is the centrepiece, of course, of the appeal. A question should constantly resubmit in the court's mind as to how does this or that proposed solution help deliver the directly effective right to which BT has been held, in principle, to be entitled in the Court of Appeal. May I ask the court briefly to actually look at the right? Very little turns on the wording, but it is, in my submission, helpful just to open it, and it is in the legal materials bundle. It is to be found in that bundle.
Is this the Sixth Directive?
Yes.
Yep.
Because there are nuances which are not complex and I don't think are in issue, but merit emphasis. Within that bundle, it's divider 21, and within divider 21, pages 91 to 93. I'm going to start at 92, although I will reverse course in a second. So what I'm inviting the court to look at is Article 11A1 little a. The heading of Title Roman 8 is taxable amount, and the definition of taxable amount is, as you know, quote, the taxable amount shall be A, in respect of supplies of goods and services other than those referred to in B, C, and D below, everything which constitutes the consideration which has been or is to be obtained by the supplier from the purchaser, the customer, or a third party, or such supplies, including subsidies directly linked to the price of such supplies. End of quote. And you will notice the word obtained, which has been predictably the subject of guidance from the European Court, and it, as we'll see, the court says it means what it says. You're only going to be taxed your actual turnover. However, you will also note there is an element of futurity.
Is to be obtained.
Exactly. So there is no need for me to comment further. If you would be kind enough to turn the page to page 93, you will see 11C, miscellaneous provisions. We are, of course, still under the same heading, taxable amount. And here we get 11C1. Again, if I may be permitted, just to quickly read it. In the case of cancellation, refusal, or total or partial non-payment, or where the price is reduced after the supply takes place, the taxable amount shall be reduced accordingly under conditions which shall be determined by the Member States. However, in the case of total or partial non-payment, Member States may derogate from this rule. So a much more nuanced landscape there. One sees what we've described in our skeletons, the 5 gateways: cancellation, refusal, total or partial non-payment, price reduction. And we are concerned, obviously, in this case.
I mean, cancellation is presumably if the contract is retrospectively cancelled, avoided. What's refusal?
I don't know.
Does anybody know? And is there any EU guidance? No.
Nothing that I have ever seen, either in the EU or the UK. It may be, and I haven't checked the other language, because it may be that the customer
Rejects the
Exactly.
goods. Yes.
Exactly. And I remind myself, I think I'm right, in civil law systems, one can't just rescind a contract, one might need judicial intervention. So this will obviously have to do duty for 27 countries.
Yes, but under English law, under Sale of Goods Act, there's a right of rejection
Exactly.
for non-conformity with
Precisely.
contractual description and so on.
Indeed.
Yes.
And that
But
must
we're not concerned with that. We're concerned with total or partial non-payment.
Precisely.
Usually, I would imagine total non-payment.
in the case of phone bills, I must presume it's
It would be unlikely for someone to pay half a phone bill.
it would be.
Yes.
And the point I make is simply that we are concerned, as my lord has put to me, with part of these words. We know that the United Kingdom has enacted a scheme, it's Article 38, which deals with price reductions, and that was in place from, I think, about the late 80s. There is no formal scheme in our domestic legislation for cancellation or refusal. And the only observation that I would make is that these words are neutral in terms, expressly neutral in terms of whether the event takes place before or after the tax has been paid. For example, under the is to be obtained extension in Article 11A1A.
There's a provision referred to in one of the skeletons in this directive which specifically permits member states to charge tax at the invoice date, which is what we've done.
Yes.
So it envisages, the directive envisages that you may pay tax first
It does.
and then get your consideration later.
It does,
Yes.
expressly.
And in a case of, under UK law, in the case of cancellation, you would probably expect a credit note to be issued and you would deal with the VAT that way because there would be a...
Absolutely.
Yes.
And I think you...
Sorry, can I just go back? You mentioned a moment ago a scheme for price reductions, and you gave a reference for that.
Because my lady, I was thinking of Article 38
Okay.
of the general...
Regulation.
Forgive me, regulation.
Regulation
I do
38.
apologise.
Thank you.
Of what?
Of the general regulations.
VAT
so the
regulations.
1995.
Yes. And that was in the background to the Iveco litigation. I don't know that the detail particularly
Right.
matters, but that's... And my lord put to me the mention in the skeleton of an advance payment provision, and I think it was probably our skeleton that mentioned it. And it was that I had in mind when I said I would backtrack to page 91, which I now do, because there you find the provision which caught my lord's eye. You will notice that it's a different title. It's chargeable event and chargeability of tax, whereas the case before the court is entirely within the taxable amount title. But of course there is a practical interaction between the two. And focusing on Article 10, and the UK has acted entirely properly within the scope of this article in having its advance payment provisions that have led to the current situation. You see, without my reading it, that chargeable event is defined very, very broadly in 10.1. And then in 10.2, there's a basic provision from which derogations are permitted. So 10.2 reads, in part, the chargeable event shall occur and the tax shall become chargeable when the goods are delivered or the services are performed. End of quote at that point. And then there is a, however, dealing with payments on account, which obviously doesn't apply in this case. And then below that, these words, by way of derogation from the above provisions, member states may provide that the tax shall become chargeable for certain transactions or for certain categories of taxable person, either no later than the issue of the invoice or of the document serving as an invoice, or no later than receipt of the price, etc. It's the first indent under which the United Kingdom has quite lawfully required those in the position of my clients to pay early, because we've issued invoices.
Well, it says for certain transactions or certain categories, but my understanding is that the normal position for VAT is that VAT is due on the invoice. You can have people who are account on a cash basis, but that's the exception rather than the rule.
My lord is quite right, with great respect. So there is a general class in this country of people who are issuers of invoices, who are VAT registered, and they have to pay, not unreasonably, they have to pay upon the invoices that they issue, showing VAT, of course. So,
as I think you've said more than once, there's nothing wrong with that element of the UK's VAT system.
Absolutely nothing wrong, and we come back to this obviously on the tax due point,
yes.
But that's for later in the week. So that's it in terms of the directly effective right as on the face of.
Can I ask a stupid question? The Sixth Directive, which is 1977, is obviously some time after VAT was first introduced, and some time after we joined the EU. Were there no equivalent of Article 11C1 in the previous directive?
No, the previous, there was the first and the second. I'm never quite sure about the intervening 3, 4 and 5, but they were relatively, I don't say this disrespectfully, relatively primitive, but only in the sense that there was this huge task of trying to pull together all of these varying VAT systems. The French had their own, the Germans had their own. So the legislators were tiptoeing towards.
It's all about harmonisation.
It's all about.
Yeah. So until this, a great deal of flexibility was allowed to member states in the way that they implemented the general obligation to collect VAT.
My lord, indeed. And the second directive is in the bundle. I'm not going to take you to it.
And is that why your claim is confined to the period from 1st January 78? There was originally a pleaded claim going back earlier, but that disappeared.
That's right.
Yes.
That's right. So we are simply basing the claim on this
Article 11C1 of the Sixth Directive.
Absolutely, as interpreted obviously by the Court of Appeal in our own case in 2014. That's the first part of the judgment, the bit where we succeeded.
Yes.
And then useful light is thrown on this by the ELIDA case, which is in the same physical bundle at divider, is not in the same physical bundle, is in bundle 4 at electronic page 2020, physical divider 70 in bundle 4. It's headed Argos and ELIDA.
I don't think we've got the same.
My lady, so if you're using physical bundles, it's the one with divider 70 in it.
Yes, that's volume 8 on ours.
I see.
I'm afraid
so I think tabs are probably
ignore
better
me.
to.
Yes.
We run to 9 bundles,
Sorry to hear that.
plus an extra one. Anyway, divide tab 70.
Tab 70. And the reason for my showing you this is that this is the case where the Court of Justice explains the relationship between Articles 11A1A and 11C, and it's the continuum which the court sees between the two. I just need to tell you something about the facts. It's very brief. Chain of supply. Let us presume a tube of toothpaste is sold by a wholesaler to a retailer who then on-sells it to a consumer. The wholesaler does two things. It sells the toothpaste for X and levies VAT on that sum, but it also puts into circulation, targeted at the consumer, a discount voucher, which it promises the retailer, the wholesaler, will honour if the consumer takes the trouble of sending it in. So you've got a wholesaler who is selling toothpaste for X in one transaction, but putting in circulation for general enjoyment a discount voucher, which never touches the counterparty to the original sale. Question: can the wholesaler rely on 11C to reduce its VAT, notwithstanding that it has never changed the price at which it sells in the binary transaction to the retailer? Advocate General says no, you'd have to go all the way down the chain adjusting the price. The court says yes, because only taxing people on what they really get is a paramount, my word, objective. So it's that curious little story that engendered this guidance. The guidance emerges, if we're using the bundle pages, at 2082, and that's 561 of the, I think it's Weekly Law Report, is Queen's Bench. But critically, para 28 just relates what I have just told you. Para 29 bears swift reading. Para 29 on page 2082. Consequently, the taxable amount attributable to the manufacturer as a taxable person must be the amount corresponding to the price at which he sold the goods to the wholesalers or retailers, less the value of those coupons. That interpretation is borne out by Article 11C1 of the Sixth Directive, which, in order to ensure neutrality of the taxable person's position, provides that in the case of cancellation, refusal, or total or partial non-payment, or where the price is reduced after the supply takes place, the taxable amount is to be reduced accordingly under conditions to be determined by the Member States. So, one, it's true that that provision refers to the normal case of contractual relations entered into directly between two contracting parties, which are modified subsequently. The fact remains, however, that the provision is an expression of the principle, emphasised above, that the position of taxable persons must be neutral. It follows, therefore, from that provision that in order to ensure observance of the principle of neutrality, account should be taken when calculating the taxable amount for that of situations where a taxable person who having no contractual relationship with a final consumer, but being the first link in a chain of transactions which ends with the final consumer, grants the consumer a reduction through retailers or by direct repayment of the value of the coupons. Otherwise, the tax authorities would receive, by way of that, a sum greater than that actually paid by the final consumer at the expense of the taxable person. End of quote, although it may go on to give general guidance. The purpose of my reading this to you was to indicate, above all, the second sentence of para 31, this principle which binds, in a sense, 11A1A and 11C as two parts of a single unified process. So that completes the second case. The only other European case to which I would refer at this stage, without inviting the court necessarily to open it, happy to do so, is the San Giorgio case. The case can be found, I don't want to take up your time with an uncontroversial proposition, it can be found at Divider 67, it's page 1998 bundle, and it is simply the fundamental ECJ case which holds that taxes which are collected in excess of the true amount that should be due are to be refunded. I mentioned San Giorgio in part to make the point that it is a principle of European law. It is not to be found in the directives, but it is not controversial. Thank you, sir. I switched from the underlying EU right to just show you, maybe you've already looked at these, the British endeavour to implement, that is to say, Section 12 of the Finance Act 1978, which is to be found at Divider 6. Divider 6. I'm going to show you Section 12 and then the regulations made thereunder. They all date from 1978. Therefore, very close to the introduction of the Sixth Directive, 9 months after. What you see at Divider 6, Section 12, and I won't read it aloud, is at the bottom of that page. There are two preconditions. 12.1a, the taxpayer needs to have made a supply, and 12.1b, the customer needs, liable to pay an outstanding amount, has become insolvent. And 12.2 requires there to have been proof in its solvency, and 12.3 gives vires for statutory instruments. And that was given effect in practical terms by the regulations at Divider 5. One goes back to electronic bundle page 22. One sees 2nd of August 1978 the old scheme as it became known, and one sees Regulation 3, classic wording, save as the commissioners may otherwise allow direct. The claimant shall make a claim to the commissioners by including in box 8 of the return prescribed in paragraph 2 of this regulation the correct amount of the refund. And over the page we see regulations 4 through to 8, some of which are specifically referred to by Mr. Justice Miles in his judgment. 4, you will see that before a claim can be made, one has to hold, this is 4A, the insolvency documentation. 5 is preservation. 6, set off. Again, there's a reference to insolvency in 6A. 7 is a provision that the learned judge specifically prays in aid in his reasoning at paragraph 85 of his judgment as pointing towards ouster. I'll make my submission on that later, but it doesn't require my reading it out, but you can see how 7.2 defines the debt. And then over the page, the payment of refund, that regulation 8, the learned judge also specifically prays in aid that provision, at this time at para 86 of his judgment, as pointing towards ouster. Naturally, we would invite the court to take a different view. That's in essence the old scheme. There's a small, not unimportant hole to plug in the bundle, but I don't think it affects the court. We haven't put in the subsequent version of the old scheme in section 22 of the VAT Act that followed it.
1983.
Yes, that's right. And we will put that in.
It didn't affect any change of substance.
It's just correct that we have it. But
yes.
What you've got is what the learned judge focused on, and it is sufficient for your purposes. What you've got in the sense of what I've just shown.
Just before we leave the regulations, I think you don't dispute that under Article 11C1, member states are entitled to set the conditions for the application of Article 11C, and that includes procedural conditions such as the requirement to make a claim.
Absolutely. and that discretionary zone, as it were, while it has been curtailed by the decision of this court in Iverco, because Lord Justice Nugee, giving a leading judgment, indicated that there were quite serious limits on member states' discretion to prevent the operation of 11C by having obstacles undefined. But undoubtedly there is a discretion, and would be even without the derogation that I expressly read to you.
There's a difference between setting conditions under the first limb and the right of derogation under the second limb.
Indeed.
Although precisely what is what is another matter, but
Yes.
I think it's common ground that the ability to set conditions enables you to say that if you want bad debt relief or any other relief under Article 11C1, you have to make a claim for that purpose to the commissioners.
Yes.
That's
Entirely common ground, no challenge.
Yeah.
I pray the point in A later,
yes.
like this, because legal certainty perhaps requires one to know how far the discretion has been lawfully exercised or conditions have been lawfully imposed. But that's for a later point. There is a legal certainty point that we have, which is just to say, well, this can be moulded, doesn't tell us precisely in what way it's going to be moulded and which of the conditions will be upheld and not moulded and which will be moulded. That's a separate story. But the answer
Can I ask a question on that? You will probably be coming to this later, but it's not clear to me at the moment in what fashion it has been decided or argued these provisions should be or have to be moulded in order to give effect to the underlying EU obligations.
well, my Lord, subject to correction, I'm not aware that we have any more detail on that very important subject than what fell from the Court of Appeal in 2014, which is that broad statement that it can be moulded. You've seen, and I'm bound by that, you can imagine that there might well have been an argument that you can't really put a blue pencil through what we've just read, and it ought to have been disapplied, but I'm not sure that's
Your understanding or submission is based on an application of leasing rather than disapplication.
Yeah, well, that is where the Court of Appeal left it.
Yeah.
And I don't think I can probably go behind that. But forgive me. Yes. And that's something to which in a sense, I made my submission now, but I'll touch on it again. So I've now shown the court the underlying EU material. The only other thing I haven't shown the court is section 39, which is the end of the story, which is divider 17. This is dated, this is in the Finance Act 1997, this is the burial of the old scheme. So that's page 75 if one's using the electronic bundle, and it's headed Bad Debt Relief. And the important thing from our point of view is over the page, it's 39, subsection 5, which reads, no claim for a refund may be made in accordance with section 22 of the VAT Act 1983, bracket, old scheme for bad debt relief, close bracket, at any time after the day on which this act is passed.
That was the 19th of March, wasn't it?
My Lord, it was indeed. So I pass now to my second block, which is just to give some high-level submissions as to what we respectfully say wasn't dealt with correctly below, and obviously the area of the judgment, the large area, that I'm addressing is the judgment below paras 65 to 105. We say that a number of things are missing, and that therefore His Lordship, with great respect, fell into error. A major point that we make is that there ought, in such a case as this, to be a very sharp and intense focus on what it is that is being ousted. That is to say, the nature of the remedy that it is proposed was implicitly abolished. And we say that because Woolwich and mistake are very different in terms of there being causes of action. Woolwich is pretty much tax specific. Mistake ranges over a very wide potential spectrum. But more importantly than that, mistake, as the court will be well aware, has a very particular list of ingredients which have to be present, including, as the name would suggest, a mistake. And there must be something about which one can be mistaken, and therefore that is an element which requires a particularly careful handling of the relationship between the proposed common law course of action and what happened. The words "what happened" are words to which I will return in a moment, but I contrast what happened in the sense of the legislation which you've just seen with a counterfactual world. I think I can perhaps be permitted to use that word, in which a moulded Section 12 and or regulations existed where everything was fine. And one of the respectful criticisms we make is that His Lordship was persuaded to look at this case as if things had always been fine. And the answer is that may or may not be how moulding works. But what actually happened is what you have just seen. And the focus, therefore, of the construction process which this court is involved in has to be both on the words of the statute, which it is said contributed to the mistake, and also the ingredients of the mistake cause of action itself. That's a very obvious submission, and I know you have that from my skeleton, but I put it at the top of the list because His Lordship appears to have, and I'll go through this in a careful manner later, not being rigorous, if I may say so, in approaching matters in that way. So that's my first general point. My second point...
At some point, Mr. Cordara, I would like to hear your submissions on precisely what the mistake was, because there's some complaint, I think, that your mistake sort of moves around a bit.
There may be. It's an unjustified mistake.
Yes. I don't take...
No,
I don't want to take you out of your course, but at some point I think I would like to be precise as to what was the mistake that you made.
I will resist temptation to engage. I will, however, share the thought that in FII 2012 there were certainly two different opinions at Supreme Court level as to what the mistake was, and they all seem to coalesce on the point they didn't make the claim. But I will come back to that.
Yes.
It is a very important point, I can say. My second point is, and again, this is something which will come out very strongly of FII 2012 in my submission. The entire exercise of deciding whether or not to oust has to be infused with EU law, and not just in a general sense, but in the sense of how does this or that competing answer achieve or obstruct the aim of EU law, which is to give effect to these directly effective rights, which the Court of Appeal has held exist and in respect of which the quantum is agreed. So EU law should be the driving force of a judicial assessment. And then the third point, which I have already made, but I like it, that feeds into the correct approach to the construction of the legislation, which is said to have had the effect of ouster. And one important question there is there a policy divergence between the putative ousting provision and the common law claim which is proposed to oust? And we say, obviously, if there is, and there are plenty of domestic law cases where that was the case, and ousting was allowed, if there is such a policy divergence, then it counts in favour of ousting. If, as here, there is no policy divergence, both the moulded or Section 12 and common law mistake would be pulling in the same direction, then two things follow. Number one is then going to ask oneself, well, where does the battle, where is it to be found? Perhaps its limitation. If the common law provision has a much longer limitation period, that might be a reason why Parliament would wish to oust it. But that wasn't the case here. There was no limitation period in the old scheme. It had to be abolished, but there was no limitation period. The other possibility is that there are procedural requirements which are particularly rigorous, which you wouldn't get in the common law arena. Again, the purpose of, as was implicit, I believe, in the questions put to me by the court shortly ago, a member state is entitled to require proper evidence and indeed adjustment if a debt is later paid. But that's exactly what would be required in a common law action. So there is nothing really between the two, save for this. Some of the procedural requirements, and I've read them, the ones in regulations referred to in paras 85 and 86 of the judgment, some of those actually incorporate unlawful requirements. That is to say, you must hold proof of insolvency. And it's striking that His Lordship, on one of the hypotheses, which we'll look at, said even if those are still there, they point towards ouster. And we say that cannot be right, with great respect. And one certainly can't refuse, one can't oust on the basis of the presence of procedural requirements which are themselves unlawful. So we'll come to the detail of that, obviously, when I invite the court to look at the decision in the context of those 7 or 8 points. The next point I think I've made, which is one has to look, one is construing the language of the provision, the ousting provision, as it stands in Queen's printer's copy. That I've shown you. One cannot, in my submission, either logically or consistent with legal certainty, imbue an unmanifested parliamentary intent to language which is not there. And that is a bedrock challenge that we respectfully make to reasoning below. His Lordship was persuaded to, in a sense, collapse the moulded version, whatever its wording, we don't know, of Section 12 into the current reality, as it were, or the reality that was current in the period up to 1997, where my clients indeed could have made their claim, as the Court of Appeal held. And he appears to have been persuaded that for the purpose of his ouster analysis, he should look at the moulded version, a notional moulded version. Of course, he's not able, no criticism, to actually specify the wording of that version. And we say that that's fundamentally wrong. His Lordship, even at one point, as I hope to demonstrate, goes so far as to say, well, even if the offensive language is taken out, or even if it's left in, the important message that we get from Parliament in 1978 is that the UK was going to have what we now describe as the old scheme. And that Parliament was saying, this is the box, and it in his Lordship's mind meant that it was inconsistent with the continued existence of common law claims covering the same ground. I hope to make that good by looking specifically at some of his language. But that cannot be right. Number one, of course, it completely abandons any reference to European law principles. Number one, of giving directly effective rights, and number two, legal certainty. But just putting those on one side and just thinking logically, one can't construe a box. One can't. I mean, clearly there was a message from Parliament. We're going to have a scheme, and here it is. We now, with the benefit of 30, 40 years hindsight, know that it was flawed. But one can't say, either on the basis of the words that were there or the words that were not there, that message is sufficiently strong in its own right to sweep away, and I pause now, all common law claims. Well, Woolwich, I'm not here to argue, but Woolwich is very different from mistake. But mistake, which obviously is on the table today, would be the common law claim that corrects for erroneous statutory language, which leads to non-enjoyment by taxpayers of their true rights in time before that route of enjoyment is abolished. And there are three parts to that sentence. There is the misleading, the non-enjoyment, and the abolition. And it's only if all of those stars align that one gets the cause of action in mistake perfected. Because obviously one has to make good the point that the reasonable reader, or what the reasonable reader would think reading section 12. You know what our submissions are. So we say that is, for better or for worse, I'm not sure that's necessarily the challenge that we'll see. The failure to make the claim, we say, follows from that. But if, for example, the BT appeal in our particular story happened before the abolition, so if it happened in the early 90s, then it would reveal that section 12 or 22, as it perhaps was by then, was indeed a route which you could use. So everyone would just pile in, as they did with section 80. And there would be no need for, and indeed no perfection of, a common law claim for relief for the consequences of a mistake. It is only when the abolition takes place, with no one apparently in the category of my clients having made their claims, that the consequences flow. And that, without straying into other issues, that was revealed obviously in 2014. But it is only when the avenue that was there but was inadvertently masked ceases to be available, there that mistake can run. And with that submission in mind, we say, how could ouster? It's a very peculiar ouster. This is ouster post mortem, because the old scheme was dead and gone, so there was no way of interfering with its operation. Operation itself was flawed for the reasons I've given. And the real question, which His Lordship should have asked, is, as a judge administering European law at this moment, reading the decision binding upon him of the Court of Appeal in BT, i.e. that there is no statutory route open, Section 80 wasn't open, Regulation 38, we know anyway what wasn't open, the new scheme wasn't going to be moulded, so that's not open, and the old scheme's gone. So there is no, at that point of judgment, there is nothing else. Question for His Lordship should be, well, how can I ensure that the UK obeys its directly effective obligations? Here's a mistake. This is a rather uniquely British remedy, but which actually fits the bill extremely nicely, and it can be used to ensure enjoyment of the directive.
Mr. Caldera, I also don't want to take you out of your course, and maybe you can come back to this. You said earlier that you should look at the Queen's Printer version of Section 12 of the 78 Act. You've also made submissions about the relevance of abolition,
Yes.
Section 39(5), and the judge relied as one of his reasons for concluding that there was ouster on the existence of Section 39, subsection 5, as an indicator of parliamentary intention. Will you, at some point, try to help square that circle? Because I think there is a point there about the time at which you're testing parliamentary intention. He was taking account of that abolition, and actually, as I understand the submission you've just made, you are also taking account of that abolition as a relevant factor in determining whether there was ouster, even though that abolition was quite a few years after the original enactment.
Indeed. But maybe let me try and grapple with that straight away, perhaps with liberty just to return to it if further thoughts intervene. I think His Lordship was referring to it for a different reason, perhaps, than I was. I was referring to the abolition as the last piece of the jigsaw of the necessary ingredients for a mistake claim. So I was referring to it as the moment when the common law needed to step in, because it was only from abolition that we didn't have a statutory route. So that's the reason I was referring to it. His Lordship was referring to it, I believe, with a very different mindset, if I may say so. His Lordship was clearly of the view that he should regard the old scheme as essentially, albeit through moulding, doing the job that Parliament, in his opinion, wanted it to do, and therefore, in the fullness of time, and perhaps not unreasonably, Parliament took the view, well, that job is done, these are my words, not His Lordship's, and the message to the university is, we have closed the book on the old scheme. And that, as I think is implicit in my latest question, that does duty, I would say, for my purpose, because it's at that moment we've got nowhere else to go other than common law, because we can't suddenly have a Damascene moment and say, let's go for Section 22. And we've got one day left, we'll do it, in which case there would have been no consequences because we would have got our claim in because there was no time bar. But from His Lordship's point of view, it can never be higher than perhaps a rather secondary message. The ouster has to take place from the start. And although His Lordship doesn't really address this question, it must follow, if there is an ouster, it was from the beginning. But let me deal with the possibility of a secondary ouster at the end. And in a way I have, because if there was no ouster at the beginning, then the lifespan of the old scheme comes to its natural end, so be it. It lives in its particular world, and there's no logical reason why there should be a scorched earth effect in terms of other Woolwich or the mistake claim. They just potter along in their own unousted routes. So,
But I'm reducing this to a very basic proposition in relation to section 39.5. If the search, or to the extent that the search is for the intention that Parliament had when enacting the words of section 12, or what those words should be taken to mean, what Parliament thought or did when it enacted section 39.5 is nothing to the point. Am I right?
yes,
This is a starting point.
yes.
Your submission that you've been making now, it has a policy element to it in terms of how one should approach section 12 subsection 2 or its section 22 equivalent, which is a separate, perhaps not distinct, but a separate line of analysis.
Yes. And without trying to be awkward, I mean, section 12 was abolished. It was replaced, obviously, with section 22. So with leave, I may return to this important question as my lady has raised it. I think I have covered those high-level points sufficiently, and I now turn to the next phase, which is to my third phase, which is just to look at guidance from Supreme Court level, starting just going through, not starting at Woolwich. That's too far removed. What I propose to do is just invite the court to dip into Deutsche Morgan Grenfell, and then more importantly FII. Let me indicate what I have in mind in terms of the relevance. It's striking that the common law has, since the 90s, certainly the DMG, Deutsche Morgan, embraced the existence not only of mistake of law, but of mistake of law in the tax context. I've already made the point that it's an intensely statutory context, and yet it has been embraced. So, in a sense, it's so obvious that one can sometimes forget about it. But it is important in my submission, in the ouster analysis, to bear in mind that there has been a flowering, let's put it that way, of common law intervention in tax matters. Very high level point I've set, but the Deutsche Morgan case is helpful in that context, and at more than perhaps that very high level point of view. That is to be found in divider 34 of the bundle, page 654 of the electronic bundle. This was a case, as the court will no doubt know, which was very much motivated again by European law, and it was the case in which it was finally accepted that mistake can apply in a tax context. There is a health warning, of course, with this in terms of what's said about the moment of knowledge, that Lord Brown's dissent was vindicated in due course. I'm not therefore going to obviously touch upon any of that. But
So, yeah, can I just clarify the current status of DMG? It's been departed from in relation to the knowledge point.
yes,
You say it's still good law in relation to the points on which you rely,
I do.
even though Semprametals a year later has been overruled and Semprametals drew on DMG.
Yes, but not, I would say, in a context relevant to what we are looking at today.
Right. Although I think we are going to hear some submissions on Prudential, aren't we?
We may well do, of course. But the first cluster I was going to take you to was the definition of the mistake, and I'm mindful of the unanswered question on that front from the court. One looks first at paragraph 7 on page 661. This is Lord Hoffman. He says, at para 7, page 661 of the bundle, 565 of the report, quote, "There is no dispute that if DMG had been entitled to make a group election, it would have done so. There is likewise no dispute that DMG is entitled to compensation for breach of statutory duty or by way of restitution of tax unlawfully demanded under the principle established in Woolwich." I break off and his lordship goes on to explain the time bar problem. And mindful of my Lord Justice Nugee's question to me, and adapting those words, we say that there is or should be no dispute that if BT, on a fair reading of the old scheme, had seen that they fell within it, they would have used it. And they didn't, and that was their mistake. And it is for that reason that we say that Judge Blow was wrong when he said, but the Court of Appeal said you could use the old scheme moulded, and to which we respond, yes, the Court of Appeal told us, but if we look at the statute, it said the opposite, and that was our mistake, to miss the train, which was the moulded version of the old scheme. That's the operative mistake. We just didn't make the claim.
So what, in a nutshell, was the mistake of law that involved?
The mistake of law was that the old scheme was justified in excluding those who had not gone through an insolvency procedure with their defaulting customers from access to Article 11C1. There are potential grounds upon which that, we now know that wasn't justified, but the potential grounds, A, the construction of 11C1, B, the conditions, C, the derogation, all of which obviously were fought over for a number of years.
It's not clear to me whether your submission is that it's sufficient that you simply didn't appreciate you could bring a claim under the old scheme as moulded, or whether you need to establish you positively concluded you couldn't bring a claim, if you see the difference.
I do. I'm thinking of the evidence in DMG of Mr. Thomason. We may come across it. He was the head of the tax department. He was cross-examined in front of Mr. Justice Park, and I think at every level, including House of Lords, there is a reference made to his answers, and the gist of it. I'll try and give you the reference, but the gist of it was, I read what the law was, and I presumed that was the law.
Yes, but this is a factual question.
Precisely.
What the evidence is going to be in your case, and might depend on how you put your, what is it that you set out to prove, which might depend on what you've pleaded. I mean,
Yes.
I raise these points because I may be wrong, but I thought I detected in HMRC's skeleton a criticism that you'd not been precise as to what it was that your mistake was.
My lord is right. There is a criticism, and our answer, and what I have done in answering is trailed the factual evidence that we would give were this to go to a trial. We have.
Well, what I've written down is the operative mistake was that we missed the train, but that leaves open. And then I've written down that in answer to my lord, the mistake was in thinking that the old scheme was justified in excluding those who had not gone through an insolvency procedure. But I'm still not clear whether your case. I mean, at this stage we're just at a strikeout. But I think we do need to understand what your case is, as a matter of fact.
Of course.
And I think there is a difference, as I said a moment ago, between just it not occurring to you that you might have an EU claim, which would enable you to use the old scheme suitably moulded and challenge the insolvency requirement, as ultimately you did, but too late, and sitting down with your advisors and looking at the Sixth Directive and looking at Regulation 12 and thinking, no, I don't think we can do anything about it, which is a very different state of mind. And this is ultimately a question, I think. Mistake is not a question of what you do, it's a question of what you believe. I may be wrong about that, but that's how I understand the word mistake.
I would submit it's both. Because what you, and indeed it's what you didn't do, that is.
But this is where I have I think this is getting to the heart of it, because saying the mistake was missing a train, not bringing a claim. One of HMRC's points is, well, everybody who has a claim but doesn't bring it can say, well, I made a mistake, I didn't bring it. But that's not what I understand this restitutionary claim to be founded on. If one starts with a mistake of fact, to establish a mistake of fact, you need to prove, I think, a subjective belief that X is the case, when it turns out X is not the case. And that was extended in Claimant events into mistakes of law. I would have thought you again need to prove a subjective belief that the law is X, and it turns out the law is not X. I, for my part, don't think it's enough to say I didn't bring a claim, that was a mistake. Now, in ordinary language, that might be a mistake. If I had a claim, it would have been a sensible thing to do to bring it. And not bringing a claim can be said to be a mistake. But it's like saying, I went to a station to catch a train, but by mistake I left too late. That's a description of what I've done. But that's not what we're talking about, as I understand it in the restitutionary context. We're talking about your false beliefs. So, what is the one you plead and rely on as being your false belief?
My lord, just before I answer that question directly, I would not dissent from any of the propositions that you put to me. And mistake is too elastic a word. We believed that our rights were, or lack of them, were as set out in the statutory words of the old scheme.
I see.
We believed, therefore, that the insolvency condition applied, and we believed that because it applied, we couldn't get through the door, and we therefore missed the train, didn't make our claim. I'll try and stay away from those rather vague phrases.
Well, no, that's very clear. Thank you.
And we have shared I can't remember if the witness statement is in the bundle, but we have certainly shared our witness evidence long ago with the Commissioner. So if we ever get...
I don't think I haven't studied supplementary bundle, but it's not in the original supplementary
No,
bundle.
may not be.
I'm not sure we have it at all.
We have your Part 18 response, and I think that's all we have on this topic.
All right, but and it may be we'll ponder whether it's helpful or not. But
Well, it may be. We'll wait to see the way in which HMRC put it, insofar as they still have a criticism. But it's now, at any rate, much clearer to me what you say your mistaken belief was.
I'm most grateful, and I will pass on then from Lord Hoffman, para 7, still on the question of defining a mistake, although I should do this quickly because time is passing now, to para 32 on page 668. So still under the topic that we're essentially discussing right now. At 32, Lord Hoffman says 2 footnotes on the question of mistake. First, Mr. Justice Park took a rather sophisticated view of the nature of the mistake. He said that the mistake was not about whether ACT was payable. DMG had not made an election, and therefore it was payable. The mistake was about whether DMG should have been allowed to elect. But I agree with the Court of Appeal that the mistake was about whether DMG was liable for ACT. The election provisions were purely machinery, which DMG would undoubtedly have used, by which it could enforce its right to exemption from liability. So that's something that's said there on the mistake point. In case I don't come back to this, and purely as a footnote, or the second footnote, slightly different point though, his lordship rebutting Lord Justice Buxton's views to the contrary, says in line, I'm looking at para 33, my lords. So I've opened a mental square bracket at this point, but it's helpful just to draw the court's attention to it. He says in line 3 of para 33, it's true that there may be anomalies in the different limitation treatment of claimants who paid under a mistake and those who paid without a mistake but pursuant to an ultra vires demand. But these anomalies flow from any recognition of payment by mistake as a cause of action and not from a distinction between payments of tax and private payments. In either case, there is the possibility of alternative causes of action, with one producing more favourable treatment under the Limitation Act 1980 than the other. So close square bracket. Apologies for that detour. Para 62 stays with the definition of the mistake, but moves us to Lord Hope. And he, at para 62 on page 678, first half I won't read, he recounts everyone's view below. He at E says, differently from Lord Hoffman, I think, just below letter E, quote, I think with respect that Park J's analysis was the correct way of looking at what happened in this case. It was the mistaken belief that group relief could not be claimed that led inevitably to the liability to pay ACT, which, absent a valid claim to group relief, DMG wasn't in a position to dispute. That was where the mistake was made, of which the payment of ACT was a secondary consequence. But as Ms. Justice Park was right to recognise, if a mistake about the availability of group income relief had not existed, the ACT would not have been paid. There was an unbroken causative link between the mistake and the payment. It follows that the payments were made under a mistake. The mistake was, of course, a mistake of law, etc. And at para 143, just to close off on this, perhaps rather subtle, but if I may say so, important debate, at 143, Lord Walker, under the heading the mistake issue, I won't read 143 out. I would perhaps invite the court just to survey it, the thrust being that one should keep these things as simple as one
That's three of them. Did the other two add anything?
My Lord, I haven't marked it. So, Lord Scott, I've steered away from Lord Scott because
He dissented.
he dissented. It
Yeah.
may not, perhaps, the dissent may not infect, if I may use that word, his definition of the mistake. That's at 89 on page 688. But I'm just cautious about proffering that. And Lord Brown, I suppose I shouldn't have, in a sense, Lord Brown vindicated. I'm just seeing if there's anything I think he agrees with the others.
I think he agrees with the majority.
Okay, I'm very grateful, Mr. Ratan. So I don't think he adds anything. So that was the mistake theme. There are just a couple of other quick themes from this before I move to FII. The first theme is choice, uncontroversial, but a choice of remedies in the European law context. Choice should be protected. I invite the court to look at para 51, page 675. We're back to Lord Hope. His Lordship, under the general heading concurrent remedies, we know the outcome was, obviously, that there could be. His Lordship of 51 quotes Professor Burrows, as he was, saying at F, the starting point for a principles analysis is that in general terms, now that this concurrent liability has been accepted, a claimant ought to be free to choose between causes of action, and that it would be odd for one cause of action offering an advantage to a claimant to be knocked out by a wider cause of action, which doesn't offer that advantage. So, and his Lordship endorses that, and indeed it is inherent in the decision overall that choice was upheld. That's the subject to which matters returned in FII 2012 and 2014. And I'm just checking. 136. Yes. Lord Walker at 136 on page 702. If one just turns to the top of page 703, he says English law generally permits the claimant to choose between concurrent causes of action and concurrent remedies as best suits his interests.
I'm sorry, which paragraph is that?
My lord, this is paragraph 136.
Thank you.
But as it turns the page to the first new sentence on over the page, it's just one sentence.
You mentioned EU law in this context, but their lordships are just applying English law.
They are.
They're saying no need for any
At this
principle
point,
of EU
yes,
law.
the two are aligned, and I accept my lady's comment. And I may have overlooked 139. As I just mentioned it, Lord Walker says, or if I can just invite the court to look at 139, which perhaps feeds into the interplay between the mistake and the lack of action and so forth. Naturally, I wish the court to read the words about showing indulgence. There's a little bit more to it than that. then finally, before we leave this case, in the context of rejecting, I'm looking at 140, in the context of rejecting the Commissioner's argument that Woolwich should be allowed to, as it were, hold the field, and that nothing, that there shouldn't be a general extension into taxation matters of mistake, in the first sentence of 140, Lord Walker says, if the Woolwich principle is to be an exhaustive and exclusive regime for unlawfully exacted taxes, set apart from the general law of unjust enrichment, legal certainty would require the limits of the exception to be ascertainable with a fair degree of precision. End of quote. Although he goes on to make a reference to Lord Gough's phrase, taxes and other similar charges. Extracting that principle and seeking to reorientate it into this case, the case before the court, really takes me back to the question of moulded, how it was moulded, what are the characteristics. And I say that legal certainty, which is clearly a principle no doubt of English law, but even more clearly of European law, that itself would militate against an ouster whose limits were not crystal clear. That is all that I would draw the court's attention to in DMG. That takes me to the case of FII 2012, which you will find at divider 42 of the and there is a respectful but direct collision between the points that we make on the appeal and the analysis of this case by Mr. Justice Miles, which is to be found at paras 93 to 102. I will come to that after I've dealt with the cases. But His Lordship, at the end of the day, didn't perceive the case as being particularly helpful to him. We say it's a central case because it is dealing with, among many other things, the argument from Crown that a moulded version of the Taxes Management Act, Section 33, could do the job of and oust common law remedy. The first thing, which I think I, in fairness, should do, is take the court to that very helpful organisational passage in Lord Hope at paragraphs 9 through to about 15, where His Lordship gives a helicopter tour of the case and what matters to this court in my submission is, please look at paragraph 9, sub 2 at letter D on bundle page 878 is a central question which was answered, and the answer is helpful, we say, to this court answering the current question. Issue 1 is not relevant, although interesting. That's about the sudden curtailment of the limitation period. That's not particularly helpful. Looking at letter E, that is not relevant. And issue 4 at 10 is, having said that, Forgive me.
I'm
Yes.
not sure issue 4 is.
Issue 4. That's whether or not there needs to be a demand under Woolwich.
Yes.
Nowhere near our.
No, exactly. Not relevant.
it's
but
not.
The only one is issue 2, is it?
The only one is issue 2. I broke off because I had a memory that there was an element of issue 1 that might be relevant. If you look at para 11, there is part of the issue 1 agenda is essentially how far domestic legal systems have discretion to abolish causes of action, as it were, and that would include ousting. So there may be an element of issue 1, but my lord, I'm going to focus on issue 2, and if I pick up anything going through from the others, then I will I'll try and flag it. At para 15, not issue 2, his lordship flags a difference of opinion between Lord Sumption and I think essentially the rest of the court on whether or not, as long as there's at least one functioning common law action, that's enough, and one doesn't have to struggle to find a second one. That ultimately was referred off, as I'll show you briefly in due course, to the European Court in FII 2014, and the European Court held that all extant causes of action are to be respected and kept in place. The European Court says it's none of its business what precise domestic remedies are given, except to say that all the remedies that are given need to go on being given in the interest of equivalence and effectiveness. So I'm now going to focus on issue 2, and that is trailed, if I may use that word, by Lord Hope at letter G on page 878 of the paginated bundle. However, before I go to the decision, can I direct the court's attention to the argument which was recorded, because there seems to be a possible factual issue as to what was argued by the commissioners, and at page 873 of the bundle, 349 of the case, letters D to H, particularly D to G, this is a record of the Crown's argument, and as you can see just below D, the Crown was arguing that where section 33 of the TMA is applicable, it ousts or removes or abrogates any possible common law remedy which might otherwise exist. A claimant who's paid mainstream corporation tax levied contrary to the rules of EU law is entitled in principle to be repaid that tax, but such repayment remedy is governed by the rules of domestic law, subject only to satisfying the principles of equivalence and effectiveness. Under domestic law, the remedy for obtaining repayment of excessive tax charged under an assessment due to an error or mistake in a tax return is in section 33. The consequence under domestic law of section 33 is applying to test claimants overpayments is that their parallel common law claims for restitution of the tax are excluded. And the Learned Counsel goes on in the same vein. Munro is mentioned, and so that is what was at stake under issue 2, or an aspect of what was at stake under issue 2. Look, Lord Walker directs our attention to paras 116 to 119. I'm so sorry, Lord Hope directs our attention to Lord Walker's analysis at 116 to 119. and if I can ask you to turn to that, it's bundle page 910, report page 386. And
Sorry, where is the direction by Lord Hope?
the direction by Lord Hope, my lady, which I didn't identify, was in para 10, where he gives that helpful
Thank you
overview.
very much.
That's on page 878 of the bundle. Letter G. So he directs us to 116 to 119, that's on page 910 of the bundle. The heading section 33, and I rely obviously very, very heavily on this. 116 sets out, I won't read it, the terms of TMA, section 33. 117, these words appear. The issue on section 33 is whether it's an obstacle to the test claimants, and if so, whether it can be given a conforming interpretation under the leasing principle. In terms of the amount of tax at stake, this issue is relatively minor in the context of the litigation as a whole, as it extends only to tax charged under Schedule D Case 5, pursuant to Section 18 of ICTA, but it's still a point of some general importance. Former Justice Henderson, HMRC argued, but only it seems quite briefly, that the decision of the Court of Appeal in Monroe established that Section 33 was an exclusive remedy which left no room for any common law claim in unjust enrichment. The judge, paras given, rejected that on two grounds. First, that Section 33 didn't extend to tax levied otherwise than by an assessment. Secondly, that in any event, the national legislation must, in a St. Giorgio claim, yield to the principle of effectiveness. It now seems to be common ground that the first of these reasons doesn't hold good for tax under Schedule D5. 118, the Court of Appeal took a different approach. It concluded, paras given, that a conforming interpretation was possible and did sufficiently go with the grain of the legislation. A reference to the expression going against the grain used in relation to the Human Rights Act by Lord Roger in Guyden and Godin Mendoza. Also adopted by Lord Nichols. The conforming interpretation adopted at para 261 was that the restrictive condition about the prevailing practice in section 33(2)(a), quote, is to be read as subject to the limitation that it applies only if and to the extent that the UK can consistently with its treaty obligations impose such restriction. 119. I have grave doubts as to whether that interpretation does not go against the grain of the legislation, since, quote, the practice generally prevailing, practice condition, is of long standing and has always been regarded as an important safeguard for the public revenue. I am inclined to think that Mr. Aronson was right to call it a cardinal feature of the legislation. In my view, the leasing principle can be applied in a simpler and more natural way by not construing section 33 as impliedly setting itself up as an exclusive provision, which it didn't do expressly, unlike section 80 of the VAT Act. The test claimants submit that the application of leasing can't rework section 33 in a way that serves any relevant purpose, but to read it as non-exclusive doesn't go against this grain. It would merely exclude an implication which is itself no more than a process of statutory construction. In practical terms, the effect is the same as that which Justice Henderson reached by the second limit of his reasoning. I would therefore allow the appeal on this point, although it may not, in the end, make much practical difference. Pausing there, that's the essence of our submission, that if one is rigorous in keeping the EU objective in mind, which is to give effect to the obligation under 11C1, and mindful of those sub-principles of equivalence and effectiveness, when the question of whether or not Section 12 and Section 22 should be read as ousting, one asks the question which his lordship asked, which is, well, which gives better effect to the overarching objective? We know the answer in this case. The answer in this case would be that if there is an ouster, given the abolition, the claim remains unpaid forever, because there's the abolition, all the other statutory gateways are closed, and the only hope, therefore, is the common law claim. So the difference, of course, in this case is the abolition. I think, I can't be sure. I know Section 33 is being repealed. I'm not sure that it had by this stage, or by the stage of the events that gave rise. But in our case, to oust, given that the provision is, as it were, ousting from beyond the grave, because it's been dead and buried for a long time, it is effectively to defeat the EU law claim. And I asked rhetorically, why not just face that fact? If there's a reason why the claim should be defeated, then let it be articulated. But given that the Court of Appeal held in BT in 2014, there is no inherent time bar running in the background, and in any event, there were events which we say explained the lack of a claim. The 11C directly effective right remains fresh and in need of it being effective. I can't really put it any more cogently than I have. It's a very black and white choice. If it's ousted, we don't get our money. It's not ousted, we do. And the question for this court, as an arm of the state, is what should it rule in order to put the UK into the best possible compliance with its treaty obligations. So
that does seem, picking up a point my lady made earlier, that does seem to place some reliance on the abolition of the Section 12 regulation, Section 22
Yes.
route, as giving rise to the Mar-leasing interpretation against ouster. But I thought the discussion earlier was premised on the basis one should look at it in 1978, when it was first left the Queen's printer's hands, at which point the abolition is irrelevant.
It has two or three nuances, all of which have been deployed.
Well, is what we're doing trying to discern the intention of Parliament in 1978, or trying today to fashion Section 12 as it originally stood in the light of subsequent events, including Section 39(5), which took place, as you pointed out, almost 20 years later? Which is the exercise we should be engaged upon?
The first and foremost, the 1978 exercise, because that is the moment, the classical moment. That question was put to me by my lord, and I gave the answer that I had just repeated. So that's a solid and unchanging position. The question of the abolition doesn't touch upon that. I've brought the abolition centre stage because it's why the mistake ultimately is operative, because there's no other route to getting our money other than the common law claim, which is now in existence. And the question for the court is, I would submit, slightly different in this sense that you are entitled you have to use hindsight, number one, in assessing the ingredients of the common law claim. In the circumstances which have occurred, have all the ingredients of the common law claim come into line. One of them is the subsequent abolition, and that even if that doesn't throw any light on the original ouster question, it certainly explains why the mistake jurisdiction is switched on, as it were, at that moment. So I'm treating the abolition as, in a sense, the moment when damage accrues. Completely different purpose from any attempt at retrospectively using the abolition to tell us about what Parliament was intending in 1978. It's a pure common law, English law, this is when the damage accrued. And it's a simple practical point because it hadn't been abolished, I made the point already, forgive me for my repetition, hadn't been abolished, and we had the benefit of Lord Justice Rymer's words in the early 90s, everyone would have just used it. And there would have been no mistake claim. Got a mistake, you've got no loss. So it has that role. The third role is the European law role. And it is, I accept, more difficult to articulate. But the court is entitled to take the landscape as it finds it. And what I mean by that expression is, in deciding now, with the benefit of hindsight, whether it is the ouster agenda, assume that it existed, but it's today or wherever today is juridically, we know the impact of what that ouster would mean, that is to say, no money, given the abolition, given the events. This court at trial, would be entitled to take the same approach that we've just seen with Lord Walker and say, does that reading, that wide reading of the ouster, is that acceptable in EU law terms? Because the court can second guess the legislators on the ouster point as much as anything else. The court is entitled to say, well, you may well have intended to oust, but in the circumstances that have occurred, given the abolition, given the passing of the years, to treat that ouster as fully effective would be to defeat the directly effective rights, and we're not going to do that. And we're mindful of the fact that the mistake cause of action is never temporarily coterminous with the underlying scheme. It only clicks in when the scheme is gone, but clutching it, it's gone to its grave, in a sense, clutching its secret which was only revealed many years after it was terminated. So it is an unusual problem. But the court at a trial would be entitled to say, standing back, to give the ouster the breadth and the post-mortem effect for which the Crown must successfully contend, is in no way justified by European law. Quite apart from the more mechanical points that it is, not only does it not give effect, but it's replete with legal uncertainty as to quite how broad the ouster is itself. So I've tried, no doubt inadequately, to indicate the three different roles that I assert the abolition has.
Thank you.
So Lord Walker, as we'll see, when we turn to Mr. Justice Miles, he does not his approach doesn't feature really significantly in the learned judge's approach. So let me turn to Lord Sumption, who does feature, and that, going back to 11. And so Lord Sumption is 204 to 205, 204 to 205. That is, I think if one starts at page, yes, page 948 of the bundle, 42 of the report. The other learned law lords see their lordships as being in agreement on this point. The passage I'm reading you now is referred to by Mr. Justice Miles in his section on this at paras 93 to 102 of his decision. I wonder if it's not unacceptable if I could just ask the court to scan 204 and 205, and then I can make a submission on it. So I naturally commend to the court his lordship's words between F and G. However, it is, quote, however, it is axiomatic that the courts can't imply an exclusion of unrestricted rights of action of common law where that would be inconsistent with an overriding rule of EU law that an unrestricted right must be available. And Section 33 cannot therefore be an exclusive right to recover tax overcharged contrary to EU law. Whether it is an exclusive right in other circumstances is not a point which needs to be considered in this appeal. End of quote. I think that's an oblique reference to Munro. And then he says at H, as you've read, that the combination of ousting and marleasing was, quote, wrong in principle. He says he very much doubts whether such radical surgery can be justified even under the extended principles of construction authorised in marleasing, and so on. He simply says it would be eccentric to imply an ambit for Section 33, which is inconsistent with EU law, and then to torture the express provisions so as to deal with anomalies that, but for the implication, would never have arisen. I can't perhaps be heard on that point because of the approach of the Court of Appeal, but I've already indicated that would or might have been an argument open in this case. The real point is that both the learned judges and the other members of the court coalesce around a very clear message that the way forward, well, first of all, that one, it's the FG paragraph that I've just quoted, one has to test any proposed solution by whether or not it would give effect to the underlying EU rights. I've made that point already probably too many times. And then in terms of technique, both judges consider that the combination of granting ousting status but marleasing the gateways, there Section 33, here Section 12, is not the right way to go, and that the better way is simply, and Lord Walker puts this more clearly, I accept, the better way is to simply achieve the direct effect objective by not having an ouster at all and leaving the common law action to take the strain, bringing the UK into line with its treaty obligations. And
yes, I mean, both of them interpreted Section 33 in a way that did not result in an ouster in order to allow an effective remedy,
yes,
EU law purposes.
yes. And that's the argument that we would like to present at trial in this case. And with great respect to their lordships, it can't be fanciful to rely on the passages. We may ultimately be wrong, but it can't be fanciful to rely on those passages at trial. So that is, if I could just say for your note, without suggesting that you look up, Lord, these passages are agreed to. Lord Hope at paras 10, 16 and 21, Lord Brown at 121, Lord Clark at 126, and Lord Reid at 246. Just very brief excursus. The case went off to the European Court on this question that I think in respect to which Lord Sumption was in the minority. This is FII 2014, divider 77 of.
This is Lord Sumption's point that Woolwich was enough, is it?
Yes. And the only reason I'm inviting
There's tab 77.
77, I'm only inviting, and that was a separate point, but it's not, as it were, a million miles from what we're debating, because the Advocate General the Advocate General at pagination 2266 report page 1177 discussing this very point. If I go back a little bit, he starts this discussion at para 57, and I'm not going to. There's a very detailed review of British case law in this area, and he at 65 says, in my opinion, the view of Lord Sumption and of the UK government is based on a misinterpretation of the principles of legal certainty and the protection of legitimate expectations. At skipping para 66, at 67, accordingly, it is not for the court to determine the position under English law, nor is it for the court even to decide whether it's necessary to adopt the theory of the declaratory nature of judgments as accepted by the majority view of the Supreme Court. The starting point from my analysis is that as the majority accepted until the entry into force of Section 320, the companies belonging to the Aegis Group had the choice of two causes of action, the Woolwich and the Claimant Benson, by means of which to recover the ACT pay but not due. If one goes down to 71, the Advocate General goes on that point. I agree with Lord Hope and Lord Reid that the companies belonging to the Aegis Group were entitled to expect, in accordance with the principles of legal certainty and the protection of legitimate expectations, that they wouldn't be deprived of that right by a statute which, a few months after their claim was lodged, amended the related time limits without notice and with retroactive effects, he would hope. And I'll come back to that in one moment. And in para 74, he says, it's settled case law that the right to a refund of taxes levied in a member state in breach of EU law is the consequence and complement of the rights conferred on individuals by provisions of EU law prohibiting such taxes, and that's St George. And then finally at 76, without reading it aloud, he adopts an agenda which is favourable to maintaining taxpayer choice. So the approach, that was the approach taken by the Advocate General, and then the court endorses that. At page 2269 of the paginated bundle, paras 3 to 7, the court summarises the common law, in inverted commas, remedies, and the question asked of the court is at para 24, and the court's answer, which is lengthy and doesn't perhaps require any detailed exposition, it starts the relevant part starts at para 30 on page 2273, and the heading is important. The heading, of course, is the principle of effectiveness, and it repeats the San Giorgio words at 30, albeit under the label of little. And at 31, the point is made that it's up to member states to have refund systems. And at G, within 31, the court says this, quote, "The member states nonetheless have responsibility for ensuring that those rights are effectively protected in each case." At 36, it makes the point that the detailed rules governing the recovery of national taxes unduly levied are a matter for national law. The question whether such rules may apply retroactively is equally a matter for natural law, provided that any such retroactive applications don't contravene the principle of effectiveness. And at 41, the court specifically protects the mistake cause of action that was on the table for discussion in that case. I won't read it aloud. There is then a subsidiary point at 44 under a different heading of legal certainty, and I've already made this point perhaps more than once, when the court recalls that, quote, "according to settled case law, the principle of legal certainty, the corollary of which is the principle of the protection of legitimate expectation, requires that rules involving negative consequences for individuals should be clear and precise, and that their application should be predictable for those subject to them." But this really goes to the retrospective abolition point, which we don't have in this case. There is a point that comes out of this, which is it's not an entirely rhetorical question. When, if at all, is an implied ouster of a means for enjoying a directly effective right consistent with European law? I don't believe it's a question which has really been addressed. And the reason for just floating this thought is that, by definition, an implied ouster is implied. So it's something that has to be constructed from research into all the familiar questions that judges have to grapple with. But it's not flagged. I know there's a twist in the story, because in 1978 there was no mistake of law. There had not yet been identified any mistake of law claim, but we must obviously assume that it was there. But there is a suite of events that can terminate national remedies with or without adequate notice. One is legislation ending or curtailing the time bar. That legislation in Marks and Spencer's case was inadequate. The abolition, which is another means, in this case, was held by the Court of Appeal to have been adequately notified. So the abolition in terms of 39.5 passed the test. But that was 39.5. It is perhaps difficult to envisage how the ouster, if such it was, of the common law right in 1978, based particularly on language which viewed in the Queen's printer's sense, which didn't apply to my clients in 1978 or indeed thereafter, how that implicit ouster would be lawful in terms of legal certainty and or effectiveness. It's no more, I simply mention it as a factor which the court might note as a potential for argument. I haven't developed the argument. But it would be, were the court otherwise minded to conclude that such an argument has legs to the extent that leave to continue would be granted, the court might care to note that it would be one of those follow-on points that would give further comfort to a conclusion that there was no implied ouster in 1978. I move on. I've dealt with the FII cases. I'd like to turn next to the judgment, first in the context of the FII part of the story, and then secondly, going backwards into the list of more procedural, more domestic law matters, which his lordship also referred to. So, opening the judgment, the key passage is 93 through to 102, 93 to 102. He recounts the story at 94. He records the submissions at 95 and 96. If I can enter into the analysis at 96, his lordship recalls that Crown submits, quote, BT's argument is answered by the conclusion of the Court of Appeal in BT that the old scheme failed to be moulded by disregarding the insolvency condition and the associated procedural requirements, and that so reformed, the old scheme provided BT with an effective and available remedy to enforce its EU law rights. Pausing there, yes, that's right, but nothing was said by the Court of Appeal about any ouster. Indeed, quite the contrary, at paragraph 118, Lord of his judgment, Lord Justice Reimer said, acknowledged the existence in principle of parallel common law remedies, but said that they would be time barred. That's the...
Was that in the context of the 9-month period? Or more generally?
I think more generally, my lady, but okay. I should check that. But the point is, it was not on the table for the Court of Appeal to go any further than obviously answering the questions that they were invited to answer. And therefore, that first sentence of para 96, where his lordship records the Commissioner's argument, is, we say, simply the starting point. It's to tell us that there was a remedy, but obviously we didn't use it. Then carrying on with the citation in para 96, His Lordship goes on to say, the present case is therefore entirely different from the situation in FII. The court in that case held that if the domestic statute ousted the restitutionary claim, the taxpayer would have been entirely deprived of any domestic legal route to enforce its direct EU rights. Pausing again, the court has seen what the court said, and what it actually said was, the Court of Appeal have gone down an ouster route. We don't like that technique. We therefore find that a non-ouster, let me restart. The Court of Appeal has gone down a Marleasing ouster route. Marleasing to broaden the entry point, and ouster to allow the moulded provision to hold the field and dominate the area. And as you've seen, the Supreme Court said, no, we can achieve this more simply by not ousting. His Lordship does not seem to have appreciated that. In his last sentence of para 96, he just repeats that the Court of Appeal gave full and effective rights, which again is correct, but is no answer, doesn't go near an ouster point, and as I say, is no answer to the mistake point. He then goes into, at 97...
Sorry, I'm not sure I follow this. He's recording that the Supreme Court interpreted Section 33 as not ousting a restitution claim. Where's he gone wrong?
Well, he says that he's not acknowledged, my lady, that the arguments, the structure of the arguments in the two cases were, in my submission, very closely allied. You had one theoretical approach, which is open the gateway to Section 33 or Section 12 in our case by enlarging, by moulding the points of entry. By points of entry, I mean taking down the hurdles. For example, the discretion in Section 33,
Yes.
The insolvency in our case. And then give that provision, per the commissioners, an ousting effect so that as remodelled, I said holds the field, it is the only avenue.
Mm.
So what His Lordship should, in my submission, have said is that there is a parallel between the arguments that BT make in front of His Lordship, Justice Miles, which is you should not oust, and certainly not regard the Marleasing as a reason for ousting. There is a shorter route to allowing an effective remedy, which is...
I think I'm probably missing something. I think I see the parallel, but in this case, the Court of Appeal in 2014 did decide that the moulding approach was the one to take, and
I see your point.
You're stuck with that.
I see your point.
So I think I'm
yes, now I get it, because
yeah.
I think it's slightly unclear, but let me argue it both ways.
Okay.
Whether we know what the Court of Appeal said in the FII story, we know that, when I say it's slightly unclear, both Lord Walker and Lord Sumption appear to have been sceptical about the ability to Marlease.
Well, yes, but that ship's has sailed on our set of facts.
Yes, I'm not sure if they necessarily reverse it or not. But accepting the ship has sailed and that you've got, nonetheless, what they don't do is launch their own ship or get on board the Court of Appeal ship. They don't say, that's a jolly good way of doing it, we'll do it that way. They say, there is a simpler route. And no one, well, perhaps, if the Crown is asserting that as soon as you Marlease, that brings with it an automatic ouster, if that's what the Crown is asserting, then certainly there's nothing in the Court of Appeal's judgment which justifies that approach. The Court of Appeal simply said this can be moulded. You can or you could have brought your claim under it, and that was it from the Court of Appeal, and that was the answer.
Thank you.
So the answer doesn't follow, and as I say, and I'm repeating myself, forgive me, there was certainly not any fertile ground identified in FII 2012 to push it to even with the ship sailing to push it to a general ouster. So just looking in a way, I've made my points now, but let me just make sure I do justice to what was said below on this. At 97, his lordship focuses on resumption, so we don't quite know what his view. Well, we do in a sense about Lord Walker, but he doesn't explain. He says in the middle, or just above the middle of 97, quote, as he, Lord Sumption, explained, it would not matter if Section 33 provided an additional remedy as opposed to an exclusive one. Hence, the question for the court was whether Section 33, which wouldn't provide an effective remedy, should be seen as excluding the common law cause of action, which would provide an effective remedy. Pausing there, my submission, the question for the court was, you could mar lease, as the Court of Appeal have done, and then oust, or you could just leave it all as it is and let the common law claim take root. So my submission, his lordship may not quite right in the perspective, and certainly that would not be an accurate description of what Lord Walker had to say on the topic. I think I've made a sufficient submission on that now. And he then reverts at 98 and following to a point that he'd made earlier. If I can just look at the first couple of lines. The contrast between the FII case and the present case is therefore clear and complete. At 88 of BT, the court held that it had always been open to BT to bring claims, including direct claims under 11C1, under the moulded old scheme, and then he quotes it. And then at 97, and at 99, he says what would have happened if BT had made its claim. We've made our respectful criticism of his logic in these paragraphs, because he's saying what could have happened had we not made the mistake. And we say that misses the point with great respect. It in fact strengthens our case, because, as he points out, if we hadn't made the mistake, we would have had our money. And that's therefore a big point for this court to consider.
Can I just ask a question about 88 of BTCA, quoted in the middle of 98?
Yes.
This is Lord Justice Reimer saying, dealing with a point that was assumed or found by the upper tribunal, I think. In other words, he says in this part of the judgment that the upper tribunal assumed that the only method by which BT could make a claim to give effect to its EU law rights was under the procedure prescribed by Section 12. And here he deals with it on a slightly different basis, as I read the judgment, namely that that's the only procedural way in which BT claimed that it was then entitled to make that claim. In other words, is this a decision by the Court of Appeal that that is the only way, or simply a reflection of the way that BT was putting its case at the time? I think, obviously, your submission must be it's not a decision that it was the only way.
No, indeed not.
Yeah.
And I'm just wondering, since I'll just need a moment to look at the paragraphs around 88.
Yes.
Can I come back to that after the short adjournment? It's a very important question.
But the question essentially, I'm not putting it very well, but the question essentially is, how far did BTCA go in identifying the mechanisms under Section 12 as a way in which this claim should be made?
Indeed. If I can come back to you, having got more of the context, the short answer is it simply answered the questions. It was a cluster of trivial issues. However, the question is entitled to a longer answer.
I mean, one procedural answer is that it was deciding a statutory appeal under a statutory mechanism.
Entirely.
And the jurisdiction extends only to those matters, not common law matters.
Yes, we never, I was in court obviously, we never got into the common law side of it at all.
Well, you wouldn't, because there wasn't jurisdiction to do that in the courts, in the tribunals below, and therefore on appeal.
Yes, and indeed we right or wrongly, we didn't go into that story even to the point of telling the court we'd issued protective proceedings years before.
Yeah.
Wouldn't have made any difference. If so, I have to come back to my Lord's question. Can I come to my final phase, which is just to work through a series of very different points that the learned judge sets out in an earlier part of the material part of his reasoning. That is to say, paras 74 through approximately 90. 92. But in any event, there is a checklist of points which his Lordship very helpfully sets out, and this part of the submission is designed to just respond to those. The big point I make is there isn't there's no point within the checklist in which the court asks itself the question, how does this fit with EU law? It's very much a classic domestic law checklist, which one might see in any implied ouster case, whether it's to do with sewers or social security and so forth. None the worse for that, of course, save that the ultimate question must be what helps the European law analysis. So item 1 on the list, which is dealt with in paras 75 to 77, is the assertion that the old scheme was specifically enacted to implement Article 11C1 of the directive. Not sure one needed a finding on that, but that is an inference which one wouldn't quarrel with. The second sentence, the purpose of the statute was to give effect to the very right of refund now relied on by the taxpayer. We say no, the statutory words are what we read, and those didn't give effect to the right. And what his lordship, we say, how his lordship errs at this point is imputing a shadow motive to Parliament, maybe not unfairly, but ultimately the dialogue with Parliament is through the reading of its legislation. A failed attempt to give effect to European right remains a failed attempt. And if I may say so, the judicial task is difficult enough trying to interpret the words that are there rather than thought processes about words that were not put there. So his lordship, we say, begins to go wrong at this point, and it does lay the foundation for those passages later, which I was only recently citing 99 and 100, in which one is almost at the point where the court is saying, well, really the mechanism was there all along, so there's really no basis for complaining. You have my answer to that. And we see that this trend, I skipped the conditionality point at 76, which is undoubtedly right, but again, within 76, there's this question of what the UK Parliament took itself to be doing. That is not a recognised canon of construction. That's politics, not unimportant, but it's what it did that matters. 77 is the outcome of that erroneous approach in my submission, where His Lordship said, so the starting point is that the statutory claim covers the same ground as the putative common law remedy. And we respectfully take issue with that sentence from a number of directions. One of them I've already set out. The starting point is what the statute says. The second point, which we make in the skeleton, which I only lightly touched on so far, is that His Lordship doesn't have, as it were, on the table in front of him the mistake claim. He's not looking at it, then looking at the statute, then looking at the EU law position, which is what we say a judge should do in this situation, trying to maneuver all the parts into some kind of alignment that works legally. And so when His Lordship says the starting point is that the statutory claim covers the same ground as the putative common law remedy, the answer is no, it doesn't. If the putative common law remedy were Woolwich, maybe, because Woolwich is very much you turn the handle, you get the money. With mistake, equitable remedy, discretionary to some extent, one is looking at a machinery that corrects, in this case, the effects of erroneous statutory material, be it acts or instruments. So to say that if I can describe mistake as an error correction cause of action, to say that it covers the same ground as the provision which is erroneous and which is cause of the operative mistake is completely wrong, we would say, analytically. It's confusing the problem with one possible solution. And that's my respectful criticism of the first sentence of Section 77. His Lordship is right with respect to the second sentence. The foundation of BT's present case is its direct right under 11C1, leaving out the bracket. You have my submission about the territory the old scheme was intended to cover. We only know that it was intended to cover what it covered. And the strong possibility, and I'm being entirely speculative now, is that those drafting thought we have a wide discretion and we want to make sure people have really been bankrupted and the rights don't go any further. And that, we say, is the plain answer there, in which case there's a very short route.
Yes. Bennion, I think, has always identified a distinction between statutory purpose, motive and intention. Always difficult distinctions to draw, but there are passages in Bennion that I can't bring to mind that say this. And I don't think it would be disputed that the purpose of Section 12 was to give effect to EU law, or this part of 11C1.
Certainly,
but the intention, pretty obviously, was to give effect to it by allowing a claim where the customer was insolvent.
Yes.
In those circumstances.
Indeed.
So this may be a futile line of discussion, but it is in principle there's some distinction to be drawn between those things.
But indeed, I accept that, and no doubt it's a Venn diagram, and they all overlap to some extent at the edges, intention, purpose. Certainly an aspiration to give effect, but I would submit, without obviously having those specific passages in Bennion in mind, that one divines all three from the words used, not the words not used, and particularly not from unspecified words not used in a moulding process which has never been defined. So,
well, you could sometimes get the purpose from the short title or other bits of the statute than the operative word.
I accept that.
Or some report that preceded it, the travaux préparatoire and that sort of
I
material.
accept all of that. I accept all of that. But I would submit that we don't materially have those here in my submission. So, at the middle of 77, the reason I've given the statutory remedy doesn't cover the same ground as the putative point. I've made that sufficiently. And then his lordship moves to the second point, which is at paragraphs 78 through to 83. And I made my point that his lordship, one of the problems is, his lordship has set himself the task of considering an ouster analysis without correctly considering the nature of the remedy ousted. I've made that point sufficiently. The second point brings us to the series of procedural and substantive conditions. I see that it might be a convenient moment.
Yes.
I'm well on course.
You'll do all right, are you?
Yes.
Yes. 2 o'clock.
Court rise if able.
So can I ask, will the court be locked?